just wrapped up its annual term and made lots of important decisions in all kinds of areas of law, including auto insurance and premises liability. Here to break some of it down for us, we've got Tom Sinas here from the Sinas Dramus Law Firm. Tom, thanks so much for being with us.
Thanks for having me, Michelle. Nice to see you.
What is premises liability? And give us kind of the backstory here in Michigan.
Okay, I'm going to try to break this down as simply as I can. Premises liability is a clunky legal term that many people think of as slip and fall. It covers more than that, but that's how most people think of it. The idea is what legal principles apply if somebody's injured on someone else's property. That's the basic concept. All right, what is the controversy here? Well, to understand the controversy, you have to understand two things about Michigan law. The first is, when under the law do we create liability for someone else? When is someone liable to another person? Well, these concepts, there are two of them related to this. The first is duty, the idea that the law says in order to be responsible for hurting someone else, you have to have owed that person a duty. So a classic example is a lawyer owes a client a duty, a doctor owes a patient a duty, a driver owes another driver a duty. The second is you have to show that the person who owed the duty breached the duty. We call this breach, that they acted in a way that was not careful, that was unreasonably dangerous. Okay? The second set of concepts you have to understand, and bear with me here, is this idea in Michigan that we have a law called comparative fault. What does that mean? It means we have a statute, actually, that the legislature passed a long time ago that says if I hurt you and we're involved in an incident and you're hurt, you can show what I did carelessly, but I can also show what perhaps you did carelessly if you were careless. And we call that comparative fault, the fault by the plaintiff. And in Michigan, the question of comparative fault, of who's at fault, is a question we let juries decide. We let a jury of our peers evaluate the evidence and decide whether or not there has been a breach of that duty. Okay, so those are our background principles. What's so controversial here? Well, about 20 some odd years ago, the Michigan Supreme Court issued a decision that created a rule called the open and obvious rule. What's that? Well, in that case, the Supreme Court said that if someone is injured by an open and obvious condition, then the landowner owes no duty at all to that person. What does that mean? It means that if you're hurt by an open and obvious condition on the land, a judge can decide without ever letting you get your case to a jury that that condition was quote unquote open and obvious, and therefore the landowner owed you no duty, and therefore your case is dismissed. So what has happened over the last 20 years is that many cases brought by people hurt on someone else's property have been dismissed without that person ever getting their day in court. What it also has had this strange effect is if people have created unreasonably dangerous conditions on their land and they're so dangerous that they're open and obvious, they get off the hook. So it creates this perverse incentive almost to have more dangerous conditions. So that's the controversy, as quickly as I can summarize it.
Okay, so the controversy, we've got that. What did the Supreme Court decide?
Okay, so what the Supreme Court decided here is the open and obvious rule is no longer applicable when it comes to duty, meaning we're not going to let a judge say this particular thing that hurt this person is, in the court's opinion, open and obvious, and therefore we're going to dismiss the case out of hand. The court said open and obvious is no longer part of duty, meaning it's no longer something that a judge gets to decide before the case is presented to a jury. The court did say that this whole concept of somebody hurting themselves on something that may have been obvious is something that a jury can evaluate in deciding whether or not the landowner should be liable. But ultimately, the victim, the plaintiff, and the defendant need to sort that out in front of a jury the way that we do as part of our American legal system. And that's the essence of these two Michigan Supreme Court cases that were consolidated into one.
Okay, so the big question is, how are people going to be impacted by this going forward?
This is going to have a practical implication for a lot of people who either have been hurt or may be hurt as a result of a condition on a piece of property. For the last 20 years, if you asked a personal injury lawyer like myself, what are the chances of success for a victim in a premises liability case? The answer was almost quite low. most all of these cases were dismissed, which meant that people didn't get their day in court. So the bigger change here will be that people who are injured will get their day in court. It doesn't mean that they're going to win their case. It doesn't mean they're going to get rich on their case, but it means they'll get a chance. And so people should know going forward that the law here has changed in a way that gives them a fair shake that they haven't had for the last 20 years. It doesn't guarantee anything at all, and people still need to be careful and cautious and thorough about how they handle these cases, as do lawyers, but at least it gives people an opportunity. And that, I think, is the biggest change from this case.
There you go. It's up to the jury in the end then, right?
That's right. That's right.
All right, Tom. So if people want more information, if they, have something, questions about this, what do they need to do?
Well, they can find us online at www.sinusdramus.com. They can shoot us an email at info@sinusdramus.com, or they can give us a call the old-fashioned way at 616-301-3333.